Hi everyone, my name is Richard Marshall. I'm a solicitor over in England, and yeah, today I'm going to talk about leaving a non-fungible legacy. I suppose it's non-fungible in the sense that it's unique to you and you can't replace it. You only get one crack at it because when you're gone, you're gone. So it is as miserable as it sounds. We are going to talk about death, but it's an important conversation to have. Forewarned is forearmed and all that. I do feel in some ways that I'm a bit like the guy off Little Nicky, that Adam Sandler movie, who foresees all the danger that's coming and shouts about it, but no one really listens. But I don't want to be that guy. I don't want to be the guy who's shouting, "The end is near, we're all going to die," because that's a miserable way of looking at it. What I prefer to sort of coin it as is afterlife asset management. You know, we've got the two pillars of blockchain technology with decentralization and crypto security. And that the comments before there of self-custody kind of really ring true here. It's on you to look after these assets, and that's part of the pull of it, really, the appeal. But if you don't plan for not being here, then how is that going to pass when you're not here? Who's going to know where your assets are, how they're going to be accessed? Big questions. Haven't got all the answers, but we can certainly run through some of the things we need to be thinking about. This conversation really is for everyone. It's for creators, collectors, gamers, the fashionistas, everybody in between, because the underlying nature of the assets, it permeates throughout, and we all share a common fate that none of us are getting out of this alive. And this, I mean life, not the conference. Hopefully we all make it to Friday. So for creators, what do we need to be thinking about? Well, there's been a lot of chat over the past few days about IP. It seems to be a very hot topic. If you are living it and breathing it and you understand it, great. But again, if you're not here, who's looking after your assets? And are they going to understand the issues, the rights that need to be protected, what needs to be enforced? If you've infringed during lifetime any rights that you have, and someone comes after your estate, do executors understand that and know that? Royalties, if you've got a royalties wallet, if an executor gets on board and gives that to a beneficiary as part of their entitlement, they might not realise that there's potential windfalls coming into that later on if pieces are sold after your death. So again, being aware of that is really important. Unsold works and unminted works, I think, are two quite important things here, and they pull back into community engagement. Unsold works, if they are listed but haven't been sold, if you're on a subscription paying platform and that subscription payment stops, what happens there? Where does it go? How do we sort of generate the maximum value for those works posthumously as well? Unminted works kind of comes back into IP. If whatever you're creating on, if it's your sort of MacBook Pro or iPad Pro, whatever it is, the information that's living on there passes with the device. So if you say in your will that you leave all of your NFTs and crypto assets to A and residuary estate to B, your devices are going to fall within your residuary estate and go to B. So it's important to have that thought process and that conversation to work out where things need to go, not just sort of the crypto assets and NFTs, but also the physical devices to make sure that those things feed through. And then community engagement. You know, one of the best things I think about the NFT space is a community engagement in the sort of community that projects build. And for that to go over a cliff edge when someone dies, I think is quite terrifying and in some ways quite sad. That legacy doesn't continue. So again, having someone appointed to understand what happens there, to generate that posthumous legacy, to then have those unsold works, unminted works coming in and pushing on, is a real testament, I think, to the individual who's been creating. But also, you need that conversation first of all to put that into context and have the sort of positions in place. I'm talking about fashionistas here because I think yesterday it was mentioned that sort of NFTs in the fashion space are upcoming, and I quite agree. Again, there's arguably a little bit more of a sentimental approach to this side of things, in the sense of if you have a love for a piece that you're using within a metaverse or for your avatar and things. So again, you know, it's identifying your wallet wardrobe in a sense to think, well, where is that? Do people know where it is? How do they access it? And which permeates anyway with wallets, but with this was kind of the context of it really. Again, if we think of clothes in a trunk, your crypto clothes, the NFTs in that trunk, you know, with even the keys to access it, really important. You can have that conversation around allocating your favorite pieces, designer pieces, to beneficiaries. If you, again, leave your assets to A, and think, oh, well, they'll sort it out because, you know, they know that X like this and Y like that. That's not necessarily going to happen. You need that in writing in your will to play that through. And naming the right assistant, you know, I'm thinking sort of devil wears Prada here of quotes being thrown around, having the right person to deal with things when you're not here. It ties in with the creator comments before, but naming the right person to act as an executor is key. And again, considering the cost of transferring these assets, the standard point in English law, and I think generally, is that if you're benefiting from an asset, you'll pay for actually having it delivered to you or getting it. So if you don't want that burden to be put on someone, again, have that in place and have a think about that so that it's quite clear in your will who bears those costs. Games. I think, again, there's a lot of talk around NFTs and games, and there's potentially going to be quite a lot of value there going forward. It's really important to understand, in that context, what's going to happen with those interests in that sort of place, really, for the gamers. Should that game be continued after death, getting a professional in to actually play the game and develop it and maximize value potentially? Is that within the executive's abilities? Do they want the risk of doing that and the liability? Because again, there could be loss from that, and that stays on them if that happens. Is there the capacity for that loss? Ultimately, I suppose, what do you want to happen with those assets is the fundamental thing to get down, to actually be able to convey that and ensure that. And think about, again, to an extent, what beneficiaries' wishes are. If there's no comments or wishes from the deceased about that, then it may come down to what the beneficiaries want. The beneficiary may be saying, yes, blast on and play that and maximize the value. But if they are one of a number of beneficiaries, they might not all agree. So again, it's just thinking about these things to give a bit of context, because ultimately, without that, there's ambiguity. Ambiguity causes arguments. Arguments lead to additional legal fees, which nobody really wants, let's be honest. So there are then jurisdictional issues with all of this. I know yesterday there was talk around having borderless NFTs, which I think to an extent is correct. But ultimately, where you die is the law is then going to govern what happens with your assets. And not to put too fine a point on it, but we're all going to die regardless. And if you do no planning, majority of jurisdictions, the law will apply to your estate. It doesn't give a shit what you want, it will just apply generically. So if a lot of people in this space want to sort of not stick it to the man to an extent, but want to move away from that sort of centralized dictatorial way of doing things, then stopping now and not doing anything for when you pass away is arguably sort of failing at the final hurdle and letting the state decide what happens with your assets. And that's where the jurisdictional issue comes in, because obviously each jurisdiction then has different rules about what happens. But what we're looking at really is some of the issues around ownership versus control. So in England, there's this conversation around, well, actually, it should be where the person is that owns those assets. So if you have control, if you have ownership and you're in England, then the laws of England apply. The concern is, though, that actually if you hold assets on an exchange, so if something's still left with OpenSea or any other exchanges on an NFT perspective, and they are based in a different jurisdiction, would it be that jurisdiction that actually governs what's happening there? And that applies then in relation to the devolution of those estates and taxation, the devolution of the assets and the taxation of those assets. And with digital twins, the point with Damien Hirst, don't anyone saw this, he created this set of works. You could either get an NFT or the physical artwork. You got the NFT, and then you could decide if you want to at a later date to burn it within a time frame and get the bit of artwork. If you kept the NFT, he burned the artwork, which was pretty cool to see. Again, if you passed away before the decision was made and you were based overseas and he was in the UK, what would happen there? If you decided to take the artwork, but that was still in the UK again, what's going to happen there? So jurisdiction is important. The conundrum with all of this then is, I think it was mentioned earlier, write down your password phrases and seed phrases and private keys. That's all good and well, but it's quite risky. So there are data custodial services that help with that. You can leave them on an exchange, but again, FTX, and don't need to say more. There are traditional sort of vault services where things are held within vaults, jewelry, gold, silver. They are moving now, looking at custodial services for digital assets, and the idea is put it on a Ballet wallet. You can still contribute that during lifetime. All the access information's there. When you die, you provide your grant of representation, and then the access is there, which is quite good. They're normally insured, which is a reassuring thing as well. And we've got smart wallets with social recovery, which is great. Multi-signatory wallets, I quite like the idea of having a legacy wallet where you can have multi-signatories, and they will be the ultimate beneficiary. If one of them dies, then that kind of helps to put it through there. And yeah, with all this then, digital wills, very flimsy concepts. There are only a few states in the US that look at this. In reality, though, it's not just a case of writing it on a computer and that's it, or minting it as an NFT. It has to be witnessed. Sometimes physically, the witnesses have to be there to witness electronically, which is weird. You may have to have affidavits of due execution in there, and might have to have a notarial seal on there. So it's not as straightforward as it sounds in those states. And again, do your own research, 'cause I'm not qualified in any of those states to give any legal advice, but that's just off the American Bar Association website. So again, pulling all this together, traditional planning, hard copy will, think about who your executor is, specific legacies of where things are going to pass to, and where your ultimate estate's going to pass to. Expressions of wishes is great. If you don't want to write your private keys down, that's fine, but leave a note to say you're not going to do that. Again, if you want works to be minted when you're passed away, make a note of that. Playing games after that as well, really important. And I'll leave it there.
Thank you very much. Sorry to cut you off.